Hello, good afternoon and welcome. This is session 2 of the Human Resources Management training. My name is Charlie Donver-Lewis and I'm the Senior Education Officer at the Labour Relations Division of the Department of Commerce. So, last session we talked about awards, agreements and the Minimum Conditions of Employment Act, the basic building blocks from where we get our basic minimum entitlements as employees. Now today we're going to be talking about employment status. So this is the different ways that you can be employed and the different entitlements that employees get for those different kinds of employment. We're going to look at the definitions of those different kinds of employment, and we're also going to look at some of the risks of misclassification. So if we look at our first slide here, we're going to look at the two broad categories, I guess, of employment status. So the two broad categories are permanent and casual. And now we're going to go into defining those two and looking at what those two categories get in terms of entitlements. So permanent employment. This can be one of three things. It can either be full-time employment, part-time employment, or fixed-term work. Now, all of these are permanent employment. They obviously have different characteristics, but they all attract similar entitlements. They all also have the same characteristics insofar as it's all ongoing work. So it's always work that you would expect will continue. Whether you're working full-time, part-time or fixed-term, you assume you will stay with that particular employer for as long as it works out. The other characteristic is regular shifts. So whether you're full-time, part-time or fixed-term, you will be working the same shifts every week. You always know when you're going to work, when you're going to start, when you're going to finish, and that won't change over the course of the employment relationship. The other thing to be aware of with permanent employment is that permanent employees receive paid annual leave and paid personal leave. So annual leave is holiday pay, and personal leave can be used as either sick or carer's leave. Now we can go into a little bit more detail about annual and personal leave later in the show, but we're also going to do an entire session on leave a bit later on, so don't worry too much about the details of that for now. The difference there between, say, permanent employment are as follows. Full-time employees, they will generally be employed for 38 hours per week over a 5-day period. That can vary which the 5 days are, but that's generally how it works. Generally that's Monday to Friday, but it depends on the industry. For example, if someone works as a hairdresser, it's generally common practice that they would work from Tuesday to Saturday. Now, part-time employment is the same arrangement, but it's less than 38 hours per week, or it's less than 5 days per week. So someone might work Monday, Tuesday, and Thursday, but they'll work Monday, Tuesday, and Thursday every week. They always know that that's going to be their shift, when they're going to start, and when they're going to finish. Now, fixed-term employment is a little bit different. That's when someone works for a set period of time. So, for example, your business, say, might have an employee go away on parental leave. And for the period that they're away, you've got to cover their job. That would be when you would get a fixed-term contract in place. So there would be a set start time and a set finish time. But during the time that someone's employed on a fixed-term contract, they should still be receiving all the annual leave and personal leave that someone would receive if they were full-time or part-time. Now we're going to look a little bit at casual employment. So this is a different way of being employed. Generally, it's someone that works when they're needed. There isn't the same regular kind of structure to their employment. So they will be recognized as casuals from the outset. That's really, really important, that someone knows from the start of their employment relationship whether they're going to be casual, full-time, or part-time. One of the big things to be aware of also is that casual employees do not receive annual leave or sick leave entitlements. Because their employment is less regular and ongoing, there isn't that paid entitlement. However, a casual employee has to receive between 20 and 25% extra for every hour that they work compared to a part-time employee to help, I suppose, balance it out in terms of the leave that they don't receive. A casual employee will generally work for short, irregular periods. So their hours are going to vary from week to week. It won't be the same shifts. Someone might call up a casual employee and say, well, I'm going to need you for Monday, Tuesday, and Wednesday this week, but I'm not sure when I'm going to need you after that. It's much more ad hoc than a part-time employee. It's there to cover short gaps in terms of when work is needed. So there won't be those same consistent start or finish times. There won't be the same regular hours of work that, say, a part-time employee would get. Just to sort of, I suppose, hopefully illustrate that quite nicely. Sorry, I've skipped ahead a slide. They are contracted and asked to work on a when required basis. So unlike a part-time employee, there isn't the expectation that they're going to work for that one employer for as long as it works out. There's the expectation that they will work for short periods, and when that's done, they won't be required anymore. So here's some examples of the rosters for the different kinds of employment. So a permanent roster, as you can see, for Tuesday, Wednesday, Thursday, and Friday, they're working the same shifts every week. There's always the same hours, the same start and finish times, and the same shifts. Whereas a casual roster, as you can see, it's much more varied. Someone is required for different hours each week, different days each week, and there isn't the same expectation that it will be the same shifts every week. Okay, now we're going to look a little bit at the leave entitlements. So for permanent staff, the basic leave entitlements that they all will receive. For a full-timer, it will be 4 weeks of paid annual leave. So annual leave is holiday pay. It's time that an employee can take off and do whatever they wish to do with. A part-timer won't receive the full 4 weeks. They will receive a pro rata amount. And again, we'll do a full session on leave a bit later so we can go into how those different accrual rates work. An employee also will receive 10 days of paid sick or carers leave. So cumulatively, sick leave and carers leave is known as personal leave. Sick leave is exactly what it sounds like. It's leave someone can take off if they are ill or injured. They can take that time off, still get paid for it, and recover from their illness or their injury. Carers leave is a different entitlement that comes out of someone's sick leave. So that's if someone in the employee's household, say an elderly relative or a young child, if they fall ill suddenly and the employee has to take time off work to look after them, they can take that entitlement out of their sick leave, but still get paid for the time off. Obviously, in both those instances, an employee generally has to provide some sort of reasonable evidence that they actually were entitled to take that sick leave or that carer's leave. Also, permanent staff will receive 10 public holidays throughout the year. So generally, if a holiday falls on a day that someone would have otherwise worked, and they take the day off solely because it's a public holiday, they should still be paid as though they had worked for that particular day. Now that's the leave entitlements that only full-time and part-time staff get. But if someone works as a casual, they are also entitled to a few different kinds of leave. Not as many, but a few. All staff, regardless of their employment status, will receive 2 days of paid bereavement leave per occasion. Bereavement leave is leave that someone will take if someone in their family or household passes away. They get 2 days of paid leave to attend the funeral and other things like that. It's really important to realize that there's no limit on how much bereavement leave someone can take. It basically is limited by the number of relatives they have. Every time a relative passes away, an employee would be entitled to 2 days of paid leave. There's parental leave. That's an unpaid entitlement at the moment on state level, and that will be 24 months to be split between a couple. That also applies to casuals if they've been working for long enough, which is a year, which is the same as full-time and part-time employees. And also long service leave. A lot of people don't realize this, but in a casual, if they work for long enough for one business, will receive long service leave, just the same way as a full-time or part-time employee would. Obviously, there are questions about whether a casual should work for one business for 10 years, but they're not specifically excluded from taking that leave if they work for long enough. The current entitlement is just over 2 months after 10 years of continuous employment. Again, I'll go into a bit more detail about when it can be taken and when it gets paid out in the next session that deals with leave entitlements. So, what are the risks of misclassification? The risks of misclassification are essentially, if someone is classified as a casual but is actually working in what could be considered to be more of a permanent relationship, i.e. they're working the same shifts every week, they can't refuse work if they have other commitments, and they are always expected to turn up for work at the same shifts. If they work for long enough in that period, we can start to look at that as a permanent relationship. And therefore, they could make a claim for misclassification and could ask to receive things like annual leave and sick leave for the time that they've worked, as though they were a part-time or a full-time employee. So it's very, very important to make sure that if you are classifying someone as a casual, they are actually working irregular shifts, they can refuse work if they aren't able to come in, and they aren't expected to turn up for the same shifts week in, week out. All right, so that covers casual versus permanent. Now we're going to look at the difference between subcontractors and employees. This is another area that businesses can fall down on. So what is the difference between a contractor and an employee? A subcontractor is essentially someone who runs their own business. So they have their own Australian business number, they provide all their own tools and equipment, they may have staff of their own. The only difference between them and other businesses is they only do their business with other businesses, if that makes sense. So they are not an employee as far as employment law goes. They are a business that do business with other businesses, which is quite a mouthful of a sentence. Whereas obviously an employee is someone who works under the control and direction of an employer. So they work for a business and they're an integral part of that business. I guess a way to look at the breakdown would be, say someone was running a cafe. You might hire a contractor to come and paint that business, and then they would finish that work, take the money for that particular work, and then go paint a different cafe. Whereas if someone is working behind the counter at a cafe, they're more likely to be an employee because they have to be there for the business to do its core functions. And again, we have risks that can be associated with classifying someone incorrectly when you get something called sham contracting. Now, sham contracting is when, it's similar to misclassifying a casual or a permanent. It's when someone is working as an employee, but they've been classified as a contractor. So they have their Australian business number, but they don't have any of the control that a contractor would have over the work that they do. Now, this becomes a problem because contractors, as I said before, are not considered employees as far as employment law goes. So all the areas like annual leave, sick leave, minimum rates of pay, overtime, and breaks, they don't apply to contractors. So if someone is engaged as a sham contractor for, say, a year, and they're not paid any of those entitlements, but then they're found to be actually an employee, they again can make a claim for misclassification and claim back a lot of that money that they didn't receive. So it can be a bill that you weren't expecting. You may have seen recently there was an article on the Sydney Morning Herald website that talked about the billions lost due to sham contracts in construction. Now that can be obviously a problem for the employees themselves who don't receive those entitlements, but it's also a problem for the employers because if that gets found out, someone has to pay all that money back, which is obviously a bill that you don't want to have to receive if you haven't planned to receive it. So as I say, it's very, very important that if someone is being engaged as a contractor, that you classify them correctly and make sure that they actually do fulfill the role of a contractor and that you seek some advice, whether it's legal advice or from Wageline, about the characteristics of a contractor. Okay, now we're going to look a bit at some other areas of employment law, not in quite so much detail, but we're going to look firstly at apprentices and trainees. Now, generally, an apprentice or a trainee, that's someone who is working towards a qualification within the industry that they are studying, and they're getting paid for that particular time. So that they are generally going to be covered by an award and agreement. It will generally be the same award or agreement that you would get if you were working as a fully qualified member of that profession. So if you're studying to be a hairdresser with a hairdresser's apprenticeship, you're generally going to be covered by the hairdresser's award the same way you would be if you were a fully qualified hairdresser. Their rates of pay will increase with each year of the apprenticeship or traineeship. So at everyone who works in an apprenticeship or as a trainee, at their anniversary date, their rate of pay will go up slightly per week. The other really, really important thing to be aware of with apprentices and trainees is they have to be registered with the Department of Training and Workplace Development. So that's really, really important. If someone is not registered with that, then obviously the rates of pay will be higher that you have to pay them, and they won't be working towards their qualification. So it's a very, very serious offence if you do not register your trainees with the Training and Workplace Development Department. Also, it's important to be aware that they will generally have a training agreement that specifies a minimum number of hours of work per week. So that will mean that even if you can only provide a certain amount of hours, you generally have to pay them for the minimum number of hours that are specified in their training arrangement. Other kinds of employment to be aware of are trial work and work experience. Now, work experience is generally conducted through an educational institution, and that would be someone working, again, a bit like an apprenticeship but less formal. They'll be working in the industry that they're trying to eventually become fully qualified in and getting some experience while they do that. Trial work is another area that can actually cause some problems for small business owners. Generally, it's fine to do. It's generally a couple of shifts that someone will do at a workplace to ensure that they're suitable for the job and that the job is suitable for them. And often it's unpaid. Now, as I say, it's fine for employers to have that system in place, but it's really important to be aware that you have to set a specific time frame for that particular amount of trial work. Because if you have someone on trial work for too long, they can potentially make a claim that there's an employment relationship there and they should start getting paid for that time. So generally try to avoid having more than 1 or 2 shifts of trial work, depending obviously on what the job is. All right, guys, well, that's basically covering employment status. I'm just now going to go through a few of the services that we provide at the Department of Commerce. We can provide one-on-one consultations. So depending on how close you are to the metropolitan area, you can call up Wageline and make an appointment to either talk over the phone or meet face-to-face with an education officer about any employment issues that you might have in your workplace. Obviously, we can provide seminars like this one, and again, depending on how close you are to the metropolitan area, we can come out and see you. We have a subscription service on our website where you can subscribe to awards and news bulletin updates to make sure that you stay up to date with minimum rates of pay and then any other issues that might apply to your business. And WageLine. And as I do every week, and will continue to do every session that I do, I'm going to really plug WageLine. It's a free, confidential, and unbiased service. You can call up, you can talk about any issues that you have in your workplace, and it's not going to get reported to anyone that you've been doing anything wrong. It's going to stay between you and the person that you talk to, and you can make sure that you've got the right system in place. Obviously, if there are any claims made against your business, that won't be confidential. But if you just want to get some advice at the first instance, then it will stay between you and the person that you talk to, and it won't go any further. All right, as always, I've got to do the government disclaimer. This has been a very general overview of employment status only, and you should always seek specific professional advice before acting or not acting on the information in this presentation. I also have to just cite the article that I talked about before. That was written by N. Wallace and was in the September 17th, 2011 edition of the Sydney Morning Herald. So if anyone has any questions, I'm now ready to take any queries that you might have, whether it's about employment status or any other areas of employment law. The number here is 1-800-678-208. Hello?
Natika from Kununurra CRC. How you going?
Good. Sorry, what was your name?
Natika.
Natika, and you're from Kununurra?
I am, yep. I just wanted to clarify what you were speaking about in regards to the casual employees being being payable when they have bereavement leave.
That's correct, yes.
Okay, so how do you go about working out? So would it not be that they're just not rostered, or so if they were already rostered for those shifts and they have to have the leave, they get paid for the shifts that they would have worked?
That's correct, yes.
Okay, no problems. And when you say it's unlimited, are there specific family members that they're...
That's an excellent question, Nikita. You're quite right. The Minimum Conditions of Employment Act, which is where the bereavement leave entitlement comes from, specifies the family members that qualify someone for bereavement leave. So it's fairly close family members that would count. So generally things like people like cousins or slightly more distant relatives wouldn't attract the bereavement leave entitlement.
Okay, so sort of pretty much like mums, dads, brothers, sisters.
That's correct. If you like, you can give WageLine a call. They can define exactly, They can find the bit of the Act and clarify exactly which family members qualify.
Great, no worries. Thanks for that.
No problem. Thank you for calling.
Okay, bye.
Thank you for calling, Nikita from Kununurra. That was great. All right, well, that about does it for us today. Thank you very much for tuning in. So just as a quick summary of what we've gone over, the key differences between casual and permanent employment is the regularity and the ongoing nature of the work, and the fact that there's the expectation of ongoing work in the case of permanent employees. Also, it's very important to remember that casuals do get bereavement leave and they do get long service leave. So thank you very much for tuning in. Don't forget to join us on the 23rd of October when we'll be dealing with the induction process and putting in place a contract. In the meantime, if you have any questions, please do feel free to call WageLine on 1300 655 266. Thanks very much, guys.